All right, let's dive into a fascinating story. We're talking about a massive shopping mall landlord going head-to-head with its most important tenant. And trust me, this is way more than just a fight over an empty store. It's a high-stakes legal clash where using the wrong rulebook could literally cost millions.
So, imagine this for a second. You're the landlord, your anchor tenant, the one that brings in all the customers, just up and leaves, completely breaking their lease. What do? Can you just change the locks and start looking for someone new? I mean, it seems like it should be a simple yes, right? But oh, the law makes it so much more complicated than that.
So let's meet our players. On one side, you've got CML, the landlord of this huge mall. And on the other, Gigi, their anchor tenant. Well, Gigi suddenly abandoned ship, leaving CML with this giant, empty building and, you guessed it, a massive legal headache.
This quote just nails the landlord's dilemma perfectly. Think about it. They're stuck between two totally different legal worlds. On one hand, you've got the fast, clear-cut rules of contract law. On the other, the slower, more protective world of property law. And if you pick the wrong one, you could lose the entire game.
Okay, so this brings us to round one of our legal showdown, the termination tussle. CML, the landlord, wants out. They want to end this lease right now and find a new tenant. But can they actually do that?
So here's how the first moves play out. The landlord, leaning on contract law, basically says, you broke the deal, we're done. The lease is terminated, today. But the tenant pulls out this defense from property law. It's like a statutory shield. It says, whoa, not so fast. You have to give us formal notice and a reasonable amount of time to fix things before you can even think about kicking us out.
Now, the landlord's lawyers got pretty clever here. They tried to find a loophole. They argued that their right to end the lease didn't come from a clause in the lease agreement, but from this bigger, older set of judge-made rules called common law. And since the tenant shield only protects against rights found in the lease, they thought they'd found a slick legal backdoor.
But the tenant fires right back with what's called the purposive argument. They're essentially saying, hey, let's ignore all the fancy legal jargon for a minute. What was the whole point of this law in the first place? Well, its entire purpose is to stop landlords from suddenly throwing tenants out on the street. If a landlord can just use a clever label to get around it, the whole law becomes completely pointless. So who wins round one? Well, recent court decisions are pretty clear on this. The trend is to side with the tenant. Judges are looking past the literal words on the page and focusing on the purpose of the law, which is to protect the tenant's rights. So, yeah, the landlord's attempt to use that loophole, it was almost certainly an unlawful termination.
And that takes us to round two, the mitigation paradox. This is where the landlord's strategy gets even more twisted, with an argument that seems really smart at first, but ends up completely backfiring.
Okay, to really get this next part, you have to understand that when a contract is broken, the innocent party has two basic paths they can go down. Path one, you can affirm the contract. You keep it alive and just demand they pay what they owe. If you do this, you don't have to look for a replacement. Or there's path two, you terminate the contract. You tear it up, the relationship is over, and you sue for damages. But, and this is a huge but, if you choose this path, you have a legal duty to mitigate your losses. That means you have to try to find a new tenant.
So CML, the landlord, argues they have a legitimate interest in keeping Gigi as their anchor tenant. And that makes sense. An anchor tenant isn't just about rent. They bring in foot traffic, prestige, the whole shebang. They argued this special status meant they didn't have to mitigate, that they didn't have to go looking for a replacement. They're trying to have their cake and eat it too, sue for damages, but not have to do the work of finding someone new.
Okay, but let's pause right here. This is the pivotal question. Remember those two paths we talked about, affirm or terminate? Which one did the landlord actually choose to go down?
They chose to terminate. And boom, the second they made that choice, they locked themselves onto path two. And on that path, the duty to mitigate isn't a suggestion, it's a rule. Their whole legitimate interest argument went right out the window the moment they decided to end the lease. Now, this doesn't mean the whole anchor tenant thing is useless. Not at all. It just plays a very different role. It doesn't get you out of your duty to mitigate, but it absolutely helps you define what a reasonable search for a new tenant looks like. It means you can justify taking more time, being way pickier, and rejecting tenants that aren't a good fit, all because you have to protect the mall's overall strategy.
So after those 2 rounds of legal boxing, what's the final verdict? What's the big lesson we should take away from this whole mess?
Let's just break it down nice and simple. On termination, the landlord's big mistake was trying to be too clever, using a loophole to get around basic tenant protection laws. The right move? Just follow the rules. Give the proper notice. Simple. Then, on mitigation, their flawed logic was using their legitimate interest as an excuse to sit back and do nothing after they ended the lease. The correct approach? Get to work. Actively look for a new tenant and use that special anchor status to justify how you're doing the search.
You know, this whole case really boils down to one huge question. When the literal words of the law, the letter of the law, clash with its overall goal, the spirit of the law, which one should win? This case seems to suggest the courts are leaning towards the spirit, towards purpose. But that tension, it's right at the heart of our entire legal system. And it's definitely something for all of us to think about.